Apologies to everyone. The chair was running a few minutes late today. Had some constituents I was meeting with. We do have a quorum, I think, but I will let the secretary call the roll.
Representative All.
Here.
Representative Bentley. Yes, ma'am. Representative Bray. Representative Duval.
Here.
Representative Fraser Gordon. Representative Gooch.
Here.
Representative Justice. Representative Lewis.
Here.
Representative McPherson.
Here.
Representative Rorix.
Here.
Representative Roberts. Representative Rudy. Representative Smith.
Here.
Representative Stevenson.
Here.
Vice Chair Lockett.
Here.
Vice Chair Pollock.
Here.
Chairman Meredith.
Here. We do have a quorum and are duly constituted to do business. If everybody would please put their cell phones on silent. We will start with our agenda, but we do have a few special guests to recognize. Representative All, I think you've got guests.
Thank you, Mr. Chairman. Yeah, all the way from Philpott, Kentucky, I want to welcome my dad, Ronnie All, who's here with me today, and his fiancee, Kelly Pence. Now, for those of you who knew I grew up on a farm, he can talk a lot longer and much better about cows than I can. You'd be interested in that, so please make him feel welcome.
Representative All, I've known you for 20 years. We've not talked about cows yet.
Somebody can talk longer than you? Are you sure?
Easy now, Vice Chair.
We'll have to gavel him down.
Any other members have special guests today? All right, seeing none, we'll move towards the agenda. We're going to start with House Bill 771. Representative Lockett, if you want to head towards the table, bring anyone you have with you to the table. And if I could, I know I have a couple folks that I think are wanting to speak on this. If somebody could, you all could sign the sign-in sheet to speak on this issue, to get you all on the record. We have that still. Just a second, Representative Lockett. All right, Representative Lockett, if you want to go ahead, introduce yourself for the record, and then let your guests introduce themselves as well, and then we will proceed with testimony.
Thank you, Mr. Chairman. My name is Matt Lockett. I'm the state representative out of the 39th District.
Eric Lakin, General Counsel to the House Majority.
Suzanne Schaffer. I'm a trust and estates attorney.
So today, Mr. Chairman, we have House Bill 771, and there is a committee sub.
I've got a motion on sub from Representative Bray, a second, Representative McPherson. Are there any questions about the sub before we adopt it?
Alex, I can
give a little explanation of it, Representative Lockett.
So the only differences in the sub and the original bill are technical changes on the first page and subsequent pages, putting those in alphabetical order, renumbering those sorts of things. So that's all that the sub does.
All right. No questions on the sub. All those in favor of adopting the sub say aye.
Aye.
Any opposed? The sub is before us, and
Very
you may
good.
proceed.
Very good. Thank you, Mr. Chairman. Again, in my professional role, I'm a financial advisor, and one of the things that we do with clients in terms of wealth management is utilize trust planning. And so I'm actually going to turn it over to Suzanne. This particular bill deals with what's called a spendthrift trust. So I will turn it over to you.
Great. So the bill really seeks to add Kentucky to the growing list of states that have already adopted what's been known or what's become known as domestic asset protection trusts. There are now 20 states, all but one of our neighbors have laws to this effect. And what it is allows someone to create an irrevocable trust, put their assets into that trust, and after waiting a statutorily prescribed period of time, which in our case is 1 year, then they have creditor protection. Now, this is not for any existing creditors. You cannot put assets into a trust to avoid your creditors. We still have the Fraudulent Conveyance Act to protect us from those scenarios. But this bill would allow a grantor to preserve assets, and the way that it's drafted, it would be a completed gift for estate tax purposes. So it would allow Kentucky citizens and any others who would want to utilize our state's laws to put assets in this type of trust to protect them from future estate taxes. So if you think family farms and family businesses, this is a tool that people have been using in other states for a number of years, and we have lost out on that revenue because we don't have these types of friendly laws. So this would give the same rights to our citizens that citizens of Alaska, Nevada, South Dakota, all of those states are enjoying, and it may actually attract some outside citizens from other states to come to our state to utilize our friendly laws.
And all of our border states, with the exception of Illinois, I believe, also has this type of protective trust.
Yes.
Anything you want to add? No. We can certainly get down in the weeds on this. It's a very detailed bill. We didn't want to do that if it's not necessary. So that's...
I've got a motion from Representative Bray, a second from Representative Pollock. Representative All, I know you've got questions. Do you want to wait for the other side to come up and make their presentation? Okay. We do have someone who has signed up to testify, somewhat in opposition. I don't think it's pure opposition. I think it's just some concerns that are out there possibly. So, Tim, if you'd come forward, introduce yourself for the record, and bring your issues before us.
Tim Shank, Kentucky Bankers Association. We're not opposed to the premise behind the bill, but we think there are a number of technical issues that may be able to work through with the bill. But there are some examples of that include that on page 11 and 12, there are provisions that essentially say that a mortgage or deed of trust is enforceable against the trust. There are no exemptions for security interests. So, example, your UCCs that are out there. Perfected security interest in trust property should enjoy similar protection. Talking to a number of attorneys in the very short time that this has been out there right now, there's some concerns that this would essentially make this the most friendly state, debtor-friendly state in the union under the way it's currently drafted. Other states typically have provisions for protections for tort liability. There is not a protection built within this statute under the way it's currently written. And while we support the general concept of a spendthrift trust, I think there just needs to be some reworking of this bill and some rewriting to make it not a completely debtor-friendly state, but also recognize the rights of creditors that are currently already within other provisions of the law that this could potentially conflict with.
Thank you. Now, Representative All, I know you've got questions, and those can be directed at whichever side of the panel you need to direct them at.
I think it's for represent the sponsor and the group. So I'll be honest, I'm not super familiar with spendthrift trust. Could you tell us the difference in what that kind of trust is and why this legislation is specifically needed in the first place?
So Kentucky's allowed for spendthrift trust in a certain regard for years, as long as I've been practicing. So if you think about leaving assets to your children in trust and putting provisions in the trust that say that your children can't alienate, assign, or pledge the assets in that trust with the assets that you've given to them so that they're not squandering their inheritance after they've received it. Spendthrift trusts like that have always been allowed. And to a certain degree, people have set up spendthrift trusts for their spouses, where they've put it into an irrevocable trust and their spouse is the beneficiary. What this bill does is it takes it one step further, like the other states have, in allowing you to set up a trust for yourself where you're a beneficiary but have no control over the assets. So you've really given them away into this irrevocable trust. You can't take them back. And whether or not you receive any benefit is at the complete discretion of the trustee. And so you can't get to it unless the trustee makes a distribution. And by doing that, you are able to get it out of your estate for estate tax purposes, which is a very large benefit. In response to the comments regarding making this the most debtor-friendly state, I would argue that creditors are better protected if people are attracted to use our laws and our courts, because then whether or not it's been a fraudulent conveyance or a proper conveyance is being decided by our courts and not the courts of Alaska or Nevada or South Dakota. And from a business perspective, if our laws are more friendly, we're going to attract more business. And that's a big part of this bill as well. I don't want to continue to see clients go to Tennessee or Kentucky residents go to Tennessee because they have better laws than we do and they can better protect their families and their assets there than they can here. They're going to do it. I'd rather them do it on our soil with our courts where we're making the determination. And by having more friendly laws than, say, Delaware or South Dakota, then we're going to attract outside people as well. So it's better for Kentucky as a whole, economically.
Representative McPherson.
So maybe if you're set up a trust for yourself, is that maybe something you could do for like long-term care for yourself? Like if you want to set up a trust, but you wanted that long-term care to be paid, like if you maybe were diagnosed with a disease or something, you knew that you would possibly Alzheimer's or something like that, where you may get to where you couldn't make the good decisions, but you wanted a trustee to make those. Is that something that this would work or protect from?
So I still think that this would not get you qualified for Medicaid to pay for that type of long-term care, because the Medicaid analysis is a separate analysis. And I'm not as versed in Medicaid as I usually deal with a larger net worth client. But with the Medicaid rules, you can't be the beneficiary at all for Medicaid to say that you qualified. So it's almost two separate analysis. But that's along the right track, putting assets into a trust of which you're the beneficiary but have no control. It's just with that extra layer of Medicaid, I'm not sure that you would qualify for those benefits.
So if I could.
Go ahead, Representative McPherson.
So you're not hiding it from, or you're not putting it away. You're actually, but there's a possibility, like if you were going to be a self-pay, you might want to do that and say, you know, if I want to go into a assisted living or a nursing home or something and I'm going to be self-pay, that you might set it up a trust that the trustee then would pay your bills if you became not eligible to.
Absolutely, you could do that.
Yeah. Thank you. That's what.
Representative Smith.
Thank you, Mr. Chairman. Just a little bit. I've gone through an experience similar